See the green door?
Yeah.
You see the drawings?
Yeah. We're on the record in the case State of Ohio versus Lonnie Sheets. We are here to deal with arguments on defense motion to allow testimony concerning statements by Lisa Sheets as identified in Exhibits B and C. I have read both parties' filings on this. I have read the statements, and I have watched the video of Lisa Sheets with her encounter with the Oak Hill police. And that is that would deal with Exhibit B, the transcript of that tape. Do the parties wish to make any other argument? Otherwise, at this point, I'm ready to roll.
Your Honor, you read our briefs.
Yep.
I think it's pretty clear. Our position is they come in,
Mhm.
yours is they don't. If you don't allow them in, I want to be able to proffer them for the record.
Yes.
Establish a record for the court.
Mhm.
I have an additional witness, Kate Basham, who was at the scene with Lisa at David Yelley's and Lonnie's home at that time, who indicated that she was offered to be paid by Lisa to stab David Yelley. So she'll comment on that also.
Well, at this point, I'm just dealing with Lisa Sheets' statements for Exhibits B and C. Does the state have anything else they wish to offer?
Nothing beyond what we wrote in our
Okay.
motion. Thank you.
In addition to the hearsay evidence rules, I think there's some other evidence rules that impact on the admissibility of these statements. One is evidence rule 404A. Generally, evidence of a person's character is not admissible for the purpose of proving that she acted in conformity with that character trait. I find many of these statements violate that prohibition. Just because Lisa Sheets made threats against Lonnie, i.e. that she's a violent person against Lonnie, you can't then use that general character trait then to demonstrate that she was the one who shot David Yelley or Tabitha Sheets. So I think there's a great deal in these statements which violate that prohibition. I think under evidence rule 401, there's a relevance issue. The fact that Lisa Sheets has threatened to kill Lonnie, I don't see how that's relevant for the alleged crimes, in this case, dealing with David Yelley or Tabitha Sheets. And I feel that when you look at evidence rule 403A considerations, the court finds any relevance is substantially outweighed by the danger of confusion of issues, misleading the jury, or unfair prejudice. The fact that, and you see this in Exhibit B, Lisa Sheets talks about Paul Sheets being a sex offender and a rapist. One, there's absolutely been no evidence of that. And I think that extraneous issue violates prohibition of evidence rule 403A. But in terms of the hearsay issues, when you look at Exhibit B, I don't see evidence rule 804B3 applying. I don't see it being a statement against interest. She doesn't say she's going to commit a crime. Clearly, the thrust of it is she wants Paul and Lonnie to leave her sons alone. I don't feel that fits. Evidence rule 801D2E concerning, this is Lisa Sheets in her statements in Exhibit B. She's not a party. She's not a co-conspirator. There's no count of conspiracy. There's no evidence of conspiracy. The fact that the state's opening refers to Lonnie and Lisa working together, I don't believe is relevant for this consideration because there's simply not a conspiracy count. And the defense can point that out in their closing. But I do not believe that opens the door to Lisa Sheets statements in Exhibit B. It's not excited utterance. This is clearly she's making a statement of memory. It's not a statement describing or explaining an event while she's perceiving it. Paul has raped me. Paul is a sex offender, because Lisa Sheets is not describing or explaining an event while she's perceiving the event. Again, it sounds like a statement of memory, what she's saying in Exhibit B. And Evidence Rule 803.3, court does not find that Lisa's statement constitutes a statement of then existing state of mind, emotion, or sensation that's relevant to this case. And then concerning Exhibit C, those are the, I believe, the police reports that deal with David Yealy's phone calls. Again, I don't find it's a, well, conceivably might be a statement against interest when Lisa says she's looking to shoot, get, or do harm to Lonnie sheets. Again, that has an Evidence Rule 401, 404A, and 403 problem, so I wouldn't let it in. Again, I find Evidence Rule 801D2C doesn't apply. She's not a party opponent. There's not a conspiracy issue. Evidence Rule 803.1, present sense impression. Again, this is, well, conceivably, and I don't really think it is a present sense impression, but even if the court found that it was, the considerations of Evidence Rule 401, 403A, and 404A would prohibit its admission. Court does not find excited utterance. There's no demonstration that those statements are made under the nervous excitement that would be the guarantee of its trustworthiness. It's not a public record for the argument as set forth in the state's motion. I won't reiterate that because that's already been, everyone knows what that is. That's part of the record. And for the reasons the court has already mentioned, exhibits mental, emotional, or physical condition. Even if it would, the considerations of Evidence Rule 401, 403A, and 404A would prohibit its admission. At this point, Mr. Torres, I'll let you do it however you would like.
For the record.
Sure.
We have to have that for the record. That I would have Officer Ratcliffe say this is the interview, play the tape, ask him, does this happen? Is this true and accurate? They can cross-examine if they wish. Then in reference to D and C, I do have Officer Copus present. We have subpoenaed Kay Basham. She's been avoiding my phone calls since last week, so I don't know if she'll be present or not.
Do you have her under?
22nd, we get service on her. That's correct.
So if she would not be here, go get her.
I would ask the sheriff to go get her. Testify, at least we have her on tape, talking to our investigator, saying that Lisa Sheets offered to pay her to stab, which I think might be relevant.
Now we're getting closer to the mark. No. And why we don't have jurors in the room, let's, would be objecting to who's.
Kay Basham, her real first name is Renata.
Okay. Testimony.
Yes, Your Honor, I would object to her testimony.
Well,
She was the woman inside the trailer with Lisa and Danny Carter, and in the car with her when she was stopped.
so you're offering that under which hearsay exception?
Well, Your Honor, I think that's a direct statement. Lisa, that's an admission against interest. And I certainly think that comes in, Your Honor. She's offered to pay some person who was killed in this case, where Lisa is alleged to have directed Lonnie to do so. I guess that's what they're indicating here. That would certainly be relevant, Your Honor. If she shows up.
If she shows up. So you're arguing under 803B3, it's a statement against interest.
Correct.
the fact that he is offering to
Hey.
pay someone
Somebody.
to kill one of the victims in this
Yes,
case.
that's correct. And then after that, got into Paul too. So I know the court's ruling on that, but she was Lisa offered also money to kill Paul to the same witness.
That's Renata.
Renata K. Basham, she goes by K, because she says people can't pronounce her first name. We give you a copy of the tapes of her.
You know, it does appear to be a statement against interest at first blush.
I think it's different than, it's certainly different, I think, Judge, than the stuff on the tape with traffic stop seems to be more, needs.
Yes,
I think if she'll testify that this person, that Lisa offered her money to actually commit a violent crime, that I think sounds to me more like an admission against her.
Yep.
Criminal interest or.
it does to me as well.
And if, I might have to call her as a hostile witness, Your Honor, because I don't know what she's gonna say today. I got a tape to back it up, though.
All right. Well, let's get your. Okay.
Let's call Officer Ratcliffe. You have the tape, Your Honor. We gave you that tape.
Yes.
Yes, we need to put it in.
Okay. Let me retrieve it.
It's not here. You say he's not out there?
No, it's not.
Did somebody find him for the Oak Hill Police Department?
He doesn't work there anymore.
He doesn't.
I can explain.
I mean, do you want to?
Your Honor, we subpoenaed Officer Ratcliffe also for this purpose.
He was served.
He was served.
Was he actually personally served or?
I don't know how he was served. I didn't serve him personally.
Kim, are you on? I'll see if I can find it. Approximate date.
Probably from 22nd of April. is what I was. Or if I can make a phone call inside, present.
Sure. So I'm gonna have to look for this. What?
His other witness out there said she was not served and she had to call the clerk.
I
She
have-
seen it on the docket, so a lot of them were served. she said.
Okay. What's this witness's name?
Which witness?
This Oak Hill officer?
Robert Ratliff? I think it's Robert.
Where's the return? Don't have it. Everything I don't like to do. Here's what I want you to do. There's a subpoena for this guy. I don't see a return.
I'll go look it up.
I want you to go and look it up. I want to see if they've ever filed a return.
Hey, Judge?
Yeah.
And I could wait until, in terms of Proffer, I guess the state would stipulate that we would anticipate Robert Ratliff, the officer, were he present, he would testify that this exhibit, and did you guys mark the video? Or
We will mark it as B.
So I would stipulate that Robert Ratliff would testify that that's a true and accurate depiction of his interaction that took place on the day in question with Lisa Sheets.
That's fine.
I just have to mark it as an exhibit.
That's all I was gonna say, this is a,
What I don't want to do though, Judge, is, I've read the transcript, but I think that's the best evidence.
I agree.
I would agree with that too.
Yeah.
That's just a follow along.
Yeah, it's a helpful guide to follow along, but
Okay.
after repeated playing and careful listening, you'll catch a few other things. But
I agree with that.
Hey, Judge.
hang on, let me deal with this. So since we're stipulating to this DVD of the Lisa Sheets Stop and No Kill, do you have the need to play it? I've already seen it.
I don't think it is. I think we can mark it and we can stipulate that that's what he would testify that's a true and accurate depiction of his interaction with her.
I just like to see you, Judge.
I think that's cumulative, Judge. I know we're not in front of a jury, but I still want to say it.
Now, you've seen it. I'm just trying to think what the Court of Appeals will say to me in the future.
I mean, I've watched it. The jury isn't going to see it. Merely playing it live in court,
We're stipulating it's admitted.
it's admitted. I think you're on.
I guess we're not stipulating this admitted as evidence to go to the jury. We're stipulating that it's.
It's admitted
For-
as,
for a proffer.
for a proffer
Yeah,
as
that is
part of the
correct.
record.
Right.
Okay, what are we calling this?
I would say state's exhibit B.
Well, probably defense exhibit.
Oh, excuse me.
Yeah.
Those-
Old habits.
Old
Yes.
habits, Your Honor. Oh, I still don't have a prosecutor.
Defense exhibit B.
B, correct.
Okay.
For proffered.
For proffered.
Be proffered, correct.
Your Honor, do you have the sleeve that I?
Well, let me look.
I don't know if I can put a sticker on it.
I wouldn't put a sticker on it.
Yeah.
I've got a marker if you want a marker. I think I do. Maybe I don't.
I have one. I think I have one.
Here's a Sharpie if you need a Sharpie.
Yeah, Radcliffe was not served.
Yeah.
Fire.
The water department was.
Yeah, failure of service.
Is that where he works now?
No. They went to the water department. It says, we accept service for everybody. But he wasn't working there at the time. So thank you.
Frank, you had something for
I'm
me?
just gonna tell you, officer was not served.
Yeah, that's what we just
Failure of service.
found. Okay.
The water department was served.
Excuse me?
The Oak Hill Water Department / Police Department was served. They said, we'll take care of it. So he hadn't worked there for several months.
They're in the same office. so.
Yeah, I know.
Okay.
We took care of it. That's fine.
All right. And then,
In reference to the other statements, Your Honor, that they are what they are. I would have nothing else on those. And that would be, if you want to say C and E, defendant's exhibit proffer, that would be acceptable. to the
Okay.
Police report.
and everyone agrees those are true and accurate copies of, what is it, Sergeant Copus's police reports?
Yes.
Okay.
Correct.
Okay, so those are proffered for the record as well. And then, was Kay Basham out in the hall?
That would be it, Your Honor.
Okay,
I had another witness talking. She was served April 22nd.
Okay. Let me just make sure. Kay Basham, I just need to see the return.
We did have a lady check in that said she drew 2.5 hours and was subpoenaed by you.
That was Eva Silvers. I released her.
Here's the e-file return, Judge, if you can just use your fingers and make it larger.
Yep. That's okay. Would you grab Mandy? Yes.
And I have a phone number. I've been trying to reach her for a week. I have no.
I'll make sure we're still on. Okay, are we on?
Yes.
Okay, the records do indicate that Kay Basham was personally served. So under Ohio law, you were entitled to someone who's been subpoenaed and has been served to, and they don't appear. And they were set for 9 o'clock.
9 o'clock.
And it's now 9:15. You're entitled to ask the court to have the sheriff go find that
I would
person.
ask the sheriff to go find her, Your Honor.
Any objection from the state?
No.
Okay,
I've served at a Wheelersburg address, Judge,
All
so
right.
make it Sauter County.
so this is going to take a while.
It may take a while. She's talked to our investigator on at least 2 occasions.
Okay. I probably want to bring in the jury, because here's what I'm thinking. We're getting the Sauter County Sheriff involved. This could, I think, at the quickest be a couple of hours,
I agree.
and I think that's the fastest. I don't know if I want to have these people just sitting here for 2 hours, if not longer.
Judge, if you're talking about sending them home and telling them to come back, I agree. I just don't know what time to say.
Here's what I'm thinking about doing is we make sure we have everyone's phone number. And we tell them, look, we're going to call you and tell you when to come back or tell whenever that would be. We may be saying, come back Tuesday morning. I don't know how difficult it's going to be to find her.
Right.
I don't know.
Yeah. And you are entitled to have the sheriff go look. So,
Get phone numbers?
let's,
Phone number, yeah.
well, no, I want to make sure we'll do that once they get in
Oh,
here.
okay.
I'm going to explain that we have a witness who is not present, and we are making efforts to find that person to bring them to court, but that we don't know quite when that would be. So we're going to excuse them. And I'm going to say, please give us your phone numbers so we can call you to let you know when to come back. But I think they would enjoy waiting in the comfort of their homes as opposed to our fine accommodations.
That's correct.
Any objection to what I've proposed?
No,
from
your
the state?
objections reasonable, and I appreciate the state.
Judge, you're gonna bring them in to like admonish them, hey, we do it all the time, but can we do
But
it
yeah,
again?
I'm
Because
gonna-
they have idle hands.
Yes, I'm going to do it again, especially under these circumstances.
And they're not gonna be happy because this witness will take probably about 15 minutes if that long.
Once we excuse them, let's talk.
Thank you.
Okay, let's bring jurors in.
All rise.
Please be seated. Good morning, ladies and gentlemen. Everyone have a nice weekend?
Yep. How about you?
Yes, all the mothers had a nice Mother's Day? Okay. We are now at the point where my understanding is the defense is going to call a witness.
That is correct, Your Honor.
That witness was subpoenaed for 9 o'clock. That witness is not here. Folks, it probably, in my estimation, is going to take at least 2 hours, if not longer, to get that witness present. Witness has been subpoenaed. Defense is entitled to have that subpoena enforced. So what I want to do is make sure I have everyone's phone number, rather than have you sit here, which I'm, sure you'd rather sit here, but I'm going to say, why don't you wait at home, probably more comfortable, and make sure, I'm going to pass the legal pad around. I want to make sure I have everyone's, give me, write on it your name and phone number. I will call you yet today to let you know when to come back, whether that's today or at what point tomorrow. I know it's an inconvenience, but it's outside the attorney's control or outside my control at this point. And I think you'd be more comfortable waiting at home than sitting here. So, folks, again, you've heard this instruction. You can probably repeat it back to me. But don't read anything about this. Don't watch anything. Listen to anything. Don't let anyone talk to you about it. Don't do any investigation. You've heard a lot of evidence, but you haven't heard it all yet, and you haven't gotten your instructions of law, so you can't form conclusions or opinions yet. So, folks, I'm going to excuse you, but let's make sure before you leave that I've got your name and phone number I can reach you. So if it's a cell phone, please keep it on so I can get a hold of everyone. Any of the jurors have any questions? Okay. Anything from the state?
No, thank you, Your Honor.
Anything from the defense?
Nothing further, Your Honor.
Okay. Then, once you give me your name and phone number on the list, you're free to go, and we will get a hold of you yet today. Thank you.
Thank you.
You don't have to repeat, you just know. You don't have to get my glasses out.
That's all right.
That's what happened.
Your Honor, one other matter we might take care of in the jury room.
While we're doing this, sure.
740.
Okay.
Sir, just have a seat. If you please raise your right hand. You swear to tell the whole truth and nothing but the truth in this matter, so help you God?
Yes, sir.
I'm going to have you pull down your mask while you testify, and just so the record's clear, we're doing a proffer. This is testimony the court has ruled that is inadmissible pursuant to evidence rules 401, 403A, 404A. So at this point,
Thank you.
Mr. Toy.
Mr. Evans, state your name for the record, please.
John Evans,
And where do you live?
2770 Frederick Road, Williamsburg, Ohio.
Okay. And do you know Lisa Sheets?
Yes.
How long have you known Lisa approximately?
18, 20 years.
Okay. You recall in the year of 2020, late summer, early fall, that Lisa came to you and asked you to do something in reference to Lonnie Sheets.
Yes.
Did you tell the court what she asked you to do?
She asked me to come to Oak Hill and whoop him and bring him back to her down at her house and residence on my one floor.
Did she offer you any certain amount of money to do that?
Started out at 3,000 and she offered 1,500.
She did? Yeah. And did she actually show you the money or just offer it?
Yes, over.
And was there anybody else with her at the time she offered this money?
No.
Okay. And where were you at when this offer was tendered to you?
I was railroad hollered on the job and she come through and I was getting ready to go to the store. She said she could give me right to the country store and she asked me in her car.
The country store, that's the hub of commerce in Webster, Ohio, is that correct?
Yeah.
Okay, all right. And what do you do for a living, sir?
I paint, mainly do trees, but I do houses too.
Did she ever ask you to do anything else in reference to Paul sheets, tablet sheets for David Healy?
Not,
Okay, it was just in reference to Lonnie.
Yeah.
And as best you can remember, it was in late August, September when this occurred, or was it October? You tell me.
I'm not really sure in what month it was.
But one of those 3 months,
Yeah.
is that correct? As we discussed last night. And you declined her offer, is that correct? What did you tell her?
So I know Lonnie for looking here, Lonnie ain't never done nothing for me and I'm not involved.
Oh, sir, thank you very much.
No questions, sir. Thank you.
All right. Sir, thank you very much for coming in.
You're welcome, sir. Have a good day.
You too. So at this point, until we get Ms. Basham, we can probably go off the record.
Thank you very much, sir.
All right. So at this point, I think, do we have a set of jury instructions to talk about, or is that something the parties wish to work on and we talk about later?
I think